Good morning. My name is Stephanie L. Willis, and I will be with you this morning on Law and Crime Live. We have a great day set up for you this morning. We will continue. Court will resume in the Jessica Heeringa trial at 1:30 this afternoon. So this morning, what we're going to do is we're going to bring it back a little bit and just get some of our viewers caught up on what they've been missing. I know yesterday there was a lot of testimony provided in the Jessica Heeringa case. There was also some DNA experts who also testified in the case. And this morning, we have the pleasure of having Ryan Zelin with us this morning. Ryan, thank you so much for being with us.
Gotta just do me one favor.
Yeah.
Randy.
Randy, I'm so sorry.
But you got the R right. So
I did.
Fine.
You know, that's my bad, though. I apologize. Randy, thank you so much for being with us this morning. Now, we had some great testimony yesterday. It might have been a little boring for some. You know, when we go through some DNA analysis, of course, we have to go through, some of the background testimony. And some of that is boring for the jurors or for the viewers. But one thing that I found that was of great interest of this case, and I know you as a criminal defense attorney, you probably found it of some great interest as well, is the lack of DNA from Jessica Heeringa in this case. Let's talk about that a little bit.
What you want as a prosecutor in a case like this, the more boring, dry, but objective physical evidence, the better off you are. So the fact that we don't have what a juror would normally expect to find at a murder scene, which is some objective physical evidence that the victim was there, always makes things difficult. And keeping in mind that the definition of reasonable doubt is nothing more than anytime you need to make an important decision in your life. If you have enough information when the doctor says you need to have surgery, you don't have a reasonable doubt. But if after the doctor says you need surgery, you say to yourself, you know something? I need more information. I need another opinion. You have a reasonable doubt. So in this case, the lack of physical evidence as a juror in a vacuum, because there's other very, very damning evidence, which when we get to me, has no place in this trial. And if he is convicted, to me, will lead to a reversal.
We can definitely talk about that.
But you have the lack of the physical evidence, to me, in a vacuum, will leave jurors wondering why.
I have to agree with you there. And the fact that we do not have a body in this case, for lack of a better term, we do not have Jessica Heeringa's body. Her mother herself has not attended the trial. A lot of her, some of her family members are there, but not everyone is there because her mother still believes that she is out there and alive. And then we have this case which simply rests on circumstantial evidence that we have, but there's not that much. And so we're looking at this whole case in its entirety, and from what we have right now, we're thinking, well, what does the prosecution have? So why even, I know this is kind of more so of a circuitous question, but why even bring up the fact that they did not have any DNA evidence at the scene? What benefits does that have for the prosecution?
A good prosecutor knows, front the bad news, because it's common sense. If I tell you the bad news first, before you hear it from my adversary, it looks like I have nothing to hide. It looks like, to me, it's not that big of a deal, and let's just get it out of the way. It's also called stealing the thunder, because the defense is all ready to go at an expert and say, you didn't have this, you didn't find this, you didn't see this, that wasn't there. If a prosecutor does it ahead of cross-examination, it kind of takes the sting out of that for the defense.
Takes away that surprise element, am I correct?
Correct.
Well, we're going to get to talk about that a little bit more, but what we're going to do now is we're going to talk, or we're going to show the testimony from Michelle Schnotala. Now, if you recall, Michelle is or was Jeffrey Willis's co-worker, and her underwear was found in his possession. So we're going to take a look at some of her testimony, and we'll talk about it with Mr. Zelin when we get back.
A co-worker of convicted serial killer Jeffrey Willis took the stand in the kidnapping and murder trial of Jessica Heeringa. Michelle Shanatola's gun and underwear were found when authorities searched Willis's van and home. Shanatola, who worked with Willis at Herman Miller's, claimed he knew where she lived and would often go snowmobiling near her residence. Willis knew she had a gun, and that very same gun went missing in February 2013 before it was later discovered in his van.
Now, can you tell us the last time that you saw that firearm?
Was the weekend of February 22nd and 23rd of 2013.
I want to draw your attention to early March of 2013. Do you recall a time where you observed some snowmobile tracks around your house?
Yes.
Now, was that unusual or a normal occurrence? The snowmobile tracks, that is.
I call it unusual because it only happened one time a year.
This witness recalled the night when Willis came into work following Jessica Heeringa's disappearance.
I recall him having scratch marks on his arms.
Did you ask him about those scratch marks?
Yes.
And what did the defendant tell you about them?
He told me that he had a new puppy, a playful puppy.
And was it the puppy that caused the scratch marks?
Yes.
Authorities discovered 2 pairs of her underwear in Willis's shed. She testified there was no reason for them to be there, and she claimed Willis had a weird fascination with her undergarments.
He'd always say, "Can I have a pair of your underwear?" And I would, no.
Okay.
On cross-examination, the defense pressed her about her memory of when Jessica Heeringa went missing.
The point that's being made here is the day after Ms. Heeringa disappears, you notice those scratches. But you've testified you don't remember the date Ms. Heeringa disappeared. And so the question is, how do you know it was the day after?
I don't.
Okay.
Willis is currently serving a life sentence for another woman's murder and is awaiting trial for the abduction of a teenage girl. For Law and Crime, I'm Rachel Stockman.
Welcome back. What you saw was just a wonderful summary of Michelle Shanatola's, some of Michelle Shanatola's testimony from yesterday. Ryan, let's talk about her testimony a little bit. And we know that she was previously his coworker. We know that she knew who he was, but she talked about scratches that were found on Jeffrey Willis around the time of Jessica's disappearance. Now, as a criminal defense attorney, is that a blow for you?
Anytime there is some evidence of a struggle with, here we know now to be the defendant, but at the time, just a guy, and he comes into work with scratch marks on his arm, which are so noticeable that a coworker says something. You talked earlier about circumstantial evidence.
Right.
Those scratch marks are not direct evidence that he is responsible for this murder. What circumstantial evidence is, think of it as links in a chain.
Right.
You have a fact over here, you have a fact over there, you need to link those 2 facts.
Yes.
Each link in the chain, that piece of evidence. So the scratch marks on the arms around the time of Ms. Heeringa's disappearance, that's a link. And what a prosecutor does is links each chain to get from that one fact. Over here you want to prove that this is the guy who did it.
Right.
And over here you have what you believe to be a murder. You want to link them together. That piece of testimony is potentially very damaging because right now there is no other explanation. Now, certainly on defense, the defense attorney will get up and say, well, ma'am, isn't it true that you don't know how he got those scratches? Now, really good cross-examiner won't actually ask that ultimate question. You save that for closing argument.
Right.
But for purposes of just cutting to the chase with your viewers, ultimately that's what you want to be able to get up there as a defense attorney and say, ladies and gentlemen, that's evidence of nothing. They have not proven anything. They want you to think it means something, but there are a million different ways someone could get scratches on someone's arms. So that is nothing.
That's nothing. I think that's a great way for a great explanation for it, but it does seem that the prosecutor in me, of course, a red light is going off in my head. Well, you know, you're having scratch marks at around the same time that around the same time of Jessica's disappearance. Excuse me. Let's talk about some of the evidence that the judge allowed in this case, if we can a little bit, if we can get into that. Judge Mariotti allowed evidence of other criminal acts, specifically the murder of Blesh and the kidnapping of the teenage girl who we now know as MJN. What do you think about, and now we do know that he was already convicted for the murder of Rebecca Blesh, and we do know that that most likely would have come in. However, he's simply charged at this time with the kidnapping of MJN. So how does that affect the perspective or the minds or the way that the jurors are thinking when this evidence is allowed in?
Imagine, and I think the easiest way to answer that question is to simply say, imagine what this trial would feel like and sound like if none of that evidence ever came in. It becomes a completely different trial.
Absolutely.
One of the most important things that our criminal justice system looks to avoid is to convict someone based upon what's called a propensity. Meaning, if you killed this person 3 years ago, you must have killed this person now.
Right.
Without even worrying about what the evidence is that you killed this person now. So, sometimes in hindsight, and that's all we have, is the ability to look back when a trial's over and someone is convicted and say, okay, let's now take the eraser and erase all of the evidence of these prior criminal acts. What does this trial look like?
Well, I mean, if we're looking at it without that evidence, it's a great case for the defense, right? But in allowing this evidence in, it makes it a great case for the prosecution. In essence, the judge stated that he allowed this evidence in because it's relevant to the execution of common plan or scheme. Would you mind explaining that to our viewers? The reason, or I guess the exception around common plan or scheme. Why is that okay?
Okay. Let's, again, take a step back. What we don't want to do is convict someone based on a propensity. Again, if I am accused of stealing this pen now, and I stole a pen 4 years ago, the law says that is evidence of nothing, because I may not have stolen this pen this time around.
Right.
And we don't want someone to be convicted, not based upon the evidence in this trial, but something that happened in the past. There are exceptions to that rule. And one of those exceptions is this notion of a common plan or scheme. So if there were other crimes that I committed in the past to allow me to get to this point of being in a position to commit this crime, and again, we talked earlier about links, where we can link a prior crime or prior crimes to this particular crime. A plan, a scheme linked together. The law says that is an exception.
Well, thanks for that great explanation. What we're going to do now is we're going to throw it to some of the top news of the day. Take it away. And welcome back to Law and Crime Live. What a great top news rundown we had for you this morning. I do want to remind you all, our viewers that are here, that are joining us this morning, that court will resume in the Michigan versus Jeffrey Willis case at 1:30 this afternoon. We can assume that the judge probably had some matters that he wanted to attend to this morning, and so this afternoon at 1:30, trial will resume. This is Willis's second trial. Recall that he was convicted in November for the murder of Rebecca Blesh, and he is now facing trial for the murder of Jessica Heeringa. And he's awaiting trial for the kidnapping of the teen that's known as MJN. All three cases, we do know, are connected. And so when MJN was able to escape from his van, this is what ultimately led to the investigation for Rebecca Blesh and Jessica Heeringa. This is crazy. So the only reason why they were able to connect him to this crime was the fact that the minor at the time, MJN, she led them to him. She was able to identify him. Because other than that, we do not have an identification of the individual who may or may not have kidnapped Jessica Heeringa. Let's talk about the importance or the non-importance of identification in a case of such significance as this.
It is always, just from a common sense perspective, it's always critically important to have a witness who's in a position to identify the defendant, because think about a trial where no one can actually identify the defendant. We go back to the definition of reasonable doubt. I can certainly assure you, if you don't have anyone at a trial who can identify the defendant, aside whether or not you actually even ever make it to the trial without that identification, but assuming you did, when you talk about jurors sitting there saying, boy, do I need more information? Well, what could I possibly want to know more about? How about someone identifying the defendant?
Right.
That probably gets you much closer to an acquittal, if not a mistrial, because you won't be able to get all of the jurors to agree. So, yeah, the identification testimony is absolutely critical.
It is absolutely critical. So we do know from some of the testimony that we've heard throughout this week is that they were the only, I guess, description that they were able to provide of this individual at the gas station was someone with blonde hair and who was tall. So other than that, we really don't know. And so, but without having this identification from the minor at the time, this case probably would not have been brought forward to trial. And so we'll see where that goes with that. What we're going to do now for our viewers is we're going to throw back to some of Michelle Schnotala's testimony from yesterday, just to catch you up a bit so that you'll be prepared once trial resumes at 1:30 this afternoon. Welcome back to Law and Crime Live, where we are replaying testimony from Michelle Schnotala, who was Mr. Willis's co-worker at the time. We can say that they maybe had sort of a weird relationship, would we say, Mr. Zelin, only because of the fact that she mentioned during her testimony that he had some sort of an asphyxiation with her underwear. We know that it's important because ultimately her underwear was found in his possession. But as a criminal defense attorney, when you're sitting at that table with your client, I know that you have a poker face, but in your head, what is that saying? What are you saying?
I'm saying to myself, how are we going to deal with the fact that this seemingly very weird yet innocuous testimony is going to be very, very damaging, because it is going to present to the jury the opportunity for this defendant to have gotten this gun. Again, circumstantial evidence. We don't have a video of Mr. Willis going and getting this gun. We don't have a confession. Yes, I went into Ms. Schnotala's house. I went up into her closet. I took her gun, and this is the gun that I used. So the prosecution must get the gun into Mr. Willis's hand. And how are they going to do that? By establishing that Ms. Schnotala had a gun. She didn't lock her front door. So access into the house, not a big deal. That the gun was kept in a closet, not hidden in a case, so someone looking around the house probably wouldn't need to be very lucky to find the gun. And then you have the underwear. The underwear is important because that is proof that this guy was in this house, because how else would he have gotten this pen?
Exactly. And so just to reiterate what you're saying, it's the fact that the gun and the underwear were essentially found, they're in the same place. She said that the gun was on the top shelf in her closet, and that's where her dirty undergarments were as well. And so it can lead, that trail, as you discussed before, it can lead the links in the minds of the jury. Well, if he does have her underwear, it's possible that he may have grabbed the gun as well. But we're putting on our criminal defense hats here. The fact that she left the door unlocked, it does leave the opportunity for someone else to go inside and obtain the gun as well. Am I correct?
Well, that's certainly one way on cross-examination to cross-examine her. But I'm also wondering at the same time, how realistic is it in this day and this age that people keep their doors unlocked? Because it's a very, if I'm the defense, to me it's a very convenient excuse. How convenient. They can't establish forced entry. They can't establish that my client is there. How convenient to simply say, oh, yes, I keep my doors unlocked.
Right.
But, yeah, I think when you take that plus your argument, which is, okay, since we don't have anyone seeing Mr. Willis go there, we don't have a video of him there,
right.
We don't have his confession, then, yes, that would be another piece of potential reasonable doubt that anyone could have walked in there.
Absolutely. Well, we are going to continue forward with Michelle Schnatala's testimony. Let's take it to the courtroom. Well, we'll take it to her testimony, and we'll be back to talk to Randy when we get back. Welcome back to Law and Crime Live, where we are covering pre-trial, well, not pre-trial, but we're covering previous testimony from Michelle Schnatala in the Michigan versus Jeffrey Willis case. We did hear from Michelle Schnatala in regards to the gun, Randy, and I think that the prosecution here did as good of a job as they could in essentially trying to wrap up or tie in the fact that Jeffrey Willis did not have any permission to use the gun. He did not have any permission to be in her house. They just did not have that type of a relationship. Now, what strikes me as kind of odd is the fact that we have these snowmobile tracks. And Michelle stated that the reason why she thought or she believes that it was Jeffrey in this case is because he had been around her house before. Now, as a criminal defense attorney, I'm thinking, well, that could have been anybody. There's a snowmobile track not too far away from your home. You stated during your testimony that you live in a not more so rural area, but it's more so removed from the city. So that could essentially be anybody. Why mention these snowmobile tracks?
Because it is yet again another piece of evidence that the prosecution is using to anticipate all of the things that you are saying now. As a juror would be thinking, wait a minute, what connection does this defendant have to this person? If this is this person's gun and this was the gun that was used, how do we make the connection? They don't live together.
Right.
They don't have a relationship. So how do they do it? In these seemingly innocuous, not a big deal pieces of evidence, it's like building a house. You can't always tell what the house is going to look like when you first start building it.
Right.
So here, what has the prosecution done? They have put Jeffrey Willis in the house. How have they done that? The snowmobile tracks are one way. A juror could be sitting there saying, wait a minute, how does this guy even know where she lives?
Right.
Well, we know now he knows where she lives because she's mentioned to him, oh, snowmobile tracks. Yes, those were mine.
Right.
Puts him there and establishes that he knows where she lives. It could have been anybody's snowmobile. Well, again, we now know he has a snowmobile. We now know that he knows where she lives, and we now know that he's been there on prior occasions. So reasonable doubt doesn't mean you have to remove all doubt.
Right.
It just simply has to be reasonable. And what the prosecution is doing is starting to plant those seeds in the jury's mind. Don't worry about the fact that there's no body. Don't worry about the fact that there's no confession. Don't worry about the fact that there's not a lot of physical evidence. Don't let your intelligence be insulted. Of course it was him.
Right. Great explanation here by Randy Zelin. What we're going to do here on Law and Crime Live, as we previously stated, court will resume in the Michigan versus Jeffrey Willis case at 1:30 this afternoon. So we are going over some of the testimony from yesterday and some pretty interesting testimony that you may have missed from earlier during the week. We're going to continue playing Michelle Schnatala's testimony from yesterday so that you all can take a look and essentially be caught up. Let's take a look. Welcome back to Law and Crime Live. We were just witnessing or watching testimony from Michelle Schnatala's testimony in the Michigan versus Jeffrey Willis case. She testified yesterday, but we are replaying some of the witnesses who testified yesterday in order to get some of our viewers caught up because trial does not resume until later this afternoon at 1:30. So make sure that you are all there at 1:30, that you tune in to ensure that you don't miss a thing in Michigan versus Jeffrey Willis. We expect that Jeffrey Willis's ex-wife is supposed to testify this afternoon. So if you know like I know, I'm pretty sure the testimony will be pretty interesting, especially due to some of the evidence that has been brought out in regards to some of the things that were found in the toolbox. So be sure to tune in at 1:30 p.m. when court is scheduled to resume. We still have Randy Zelin with us. Randy, thank you so much for being with us this afternoon. I'm sorry, this morning. I apologize. We got to listen to some cross-examination, okay? Maybe not so much the best. I don't think that the defense has a lot to work with in this case. But I thought that defense attorney brought out a great point in that he kind of, I guess, did something to her testimony, I'll say, in regards to the scratches that she found or that she stated that she saw on Jeffrey Willis at the day after the disappearance of Jessica Heeringa. The defense attorney shook her up a little bit and stated that she informed the police 3 years after the fact. As a matter of fact, I believe they stated that she provided the information on September the 19th of 2016, and that she provided the information in regards to the scratch marks found on Jeffrey Willis's arms 3 years after. And so they kind of tied her down into saying that she really didn't know whether or not the scratches were found around the time of Jessica Heeringa's disappearance, because she didn't know when Jessica Heeringa disappeared. Discuss that for us a little bit.
Well, cross-examination. Couple of very simple, tried and tested rules. The first thing a defense attorney does, or prosecutor for that matter, anyone who's cross-examining a witness, the first question you ask yourself is, has this witness hurt me? Because in this business, as a lawyer, you're only one word away from talking yourself into trouble.
Right.
And you're only one question away from taking a case that you're doing pretty well with and wrecking it. And that probably happens most often with a cross-examination. You never ask a question that you don't know the answer to.
Right.
And you never get too cute, particularly if someone hasn't hurt you and it's something that you could use on closing argument where there's no one there to change their story. A rookie or inexperienced cross-examiner will oftentimes repeat a good question that hurt on direct,
right,
repeat it on cross-examination, and then the witness changes or says, oh, you know something, I was wrong.
Right.
And then it's over. I mean, you don't do that. But to your question, this cross-examination that we saw, while we don't see the rhythm, cross-examinations are rhythm. Cross-examination is all about being very well prepared, knowing what you want to do,
right,
but being flexible enough to adapt to the direct. Here, we didn't see that rhythm. What you want to do is you want to get into a rhythm with the witness, and the witness has no time to think, and it's yes, no answers. The lawyer on cross-examination is the star of the show. It's the questions that are the star, and the answers are yes and no, because you're trying to take a witness in a certain direction. Whereas on direct examination, the witness is the star.
Right.
So, yes, you're absolutely right. Critical point. But the cross-examination could have been tighter,
yes,
short questions, to the point, staccato, boom, 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 so the jury can follow it. But again, the most important point is, and it's kind of like you can win a baseball game 17-2, or you can win it 3-2. A win's a win.
Right.
You can win sloppily, or you can wreck somebody. So here, the cross may have been a little all over the place, but critical point for two reasons.
Yeah,
Number one, this witness sounded so sure on direct examination. Now, all of a sudden, not so sure. Why is that important? Because trials are about trust. You want the jurors to trust you as a lawyer. The jurors, the prosecution wants the jurors, trust me, I got this. Defense attorney wants to say, trust me, they don't have it.
Right.
So now all of a sudden, as a juror, you're thinking, wait a minute. She sounded so sure of herself. Now all of a sudden, she's not so sure. Maybe I can't trust them like I thought that I could.
Wow.
So you had that kind of underlying, well, maybe what else is there that I trusted her and I took her word at that maybe she's not so sure about. So that was a critical thing. And, of course, the timing, because as we talked about earlier, those scratches are very, very, very damaging evidence. Now, all of a sudden, wait a minute. We can't trust the timing of those scratches? Yeah, that was good.
Perfect explanation. We are going to continue forward in watching some of Michelle Schnotala's testimony from yesterday. We have Randy here to break everything down for us throughout the morning, and so please be sure to stick with us. Let's take a look at some more of Michelle Schnotala's testimony from yesterday. Welcome back to Law and Crime. We showed you some testimony from Michelle Schnotala yesterday, from her testimony from yesterday, excuse me. We had some redirect and recross. You know, I think that sometimes us as attorneys, we like to go back and make sure that we have everything tied up. Do you think that this recross was necessary by the defense in asking whether or not she was sure as to whether or not the snowmobile tracks were in January or were in March?
You just saw, and your viewers just saw, a classic example of asking a question that you really wish you could take back. There was no reason for it.
Right.
Because that was a classic example of, how do you know? Oh, how do I know? Because the only time he would run his snowmobile by my house was in March.
Right.
And at that point, you may have your poker face on, but as a defense attorney, you're saying, man, that was really dumb. Because he could have left that alone.
Right.
And just gotten up in closing argument and say, ladies and gentlemen, lots of people have snowmobiles. It's that area. It's that part of the country. There is no way in God's green earth this woman can say with any degree of certainty when it was. And don't take my word for it, because remember that critical piece of evidence that she sounded so sure about with the scratch marks?
Right.
Now all of a sudden she wasn't so sure. And there's no one there to hurt you because you're standing up there all alone in closing argument. He should have never gotten so cute. And so he was really being a wise guy.
Yeah.
How do you? Well, guess what? I do know.
Well, so that may not have been such a great move by the defense, but what we're going to do right now is we're going to take a break. You are in the middle of the Michigan versus Jeffrey Willis trial. Remember, trial will not resume until 1:30 p.m. this afternoon. But stick with us. When we come back from our break, we'll have some great coverage for you.
Crime.
Welcome back to Law and Crime Live. My name is Stephanie L. Willis, and we are continuing our coverage of the Michigan versus Jeffrey Willis case. Following this trial, if you all are not aware, but following this trial, Jeffrey Willis is expected to stand trial in the 2016 kidnapping of a teenager who we now know as Madison Nygaard, she escaped his van and went to the police, or went to the home of Dawn Schmidt, and called the police. This arrest, the leading to this arrest, on April the 16th of 2016, was essentially what led us to finding out that Jeffrey Willis, or to make Jeffrey Willis a suspect in the murders of Rebecca Blesh as well as Jessica Heeringa. So what we're going to do now, Randy, if you'll stick around with us for a little bit more, is we're going to watch the testimony of Dawn Schmidt. Dawn Schmidt, as I stated before, is the owner of the home in which the victim, Madison Nygaard, ran into to allegedly escape from Jeffrey Willis. Let's take a look. We're bringing you back to Law and Crime Live. What you just saw was a testimony from Diane Schmidt. I believe Diane Schmidt testified on the first day of trial, which began on Tuesday. And now we still have Randy Zelin with us this morning. And Randy, Diane Schmidt provided a very descriptive testimony, and she was able to provide, I guess, listening to her testimony kind of brought me into, I guess, her world at that time. Does this description, is this helpful for the members of the jury? I guess for the prosecution, is this helpful just to show how frantic the situation was?
Yes, as you just said, the jury was able to travel back in time and get a sense of what Dawn Schmidt was like, how she was behaving, because as a prosecutor, you want the person's behavior to be consistent with what it is you want the jury to believe happened. A couple of important things, though, from an evidence standpoint that we see from her testimony. It's very interesting how she was able to testify. Dawn Schmidt was able to testify about things that this kidnapping victim told her. Madison. Normally, you wouldn't be permitted to do that because that's what we call hearsay.
Right.
Anytime you have a statement made out of court and that statement is being brought into court to prove the truth of what is being said.
Correct.
The law is like, no, 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 no. We want the person who said it.
Yes.
Not what that person told you. Why did the judge allow it here? Because there are certain exceptions to the hearsay rule. It's all about, is it credible? Does it ring true? Can we let it in because perhaps that person wouldn't have had time to make it up? So in this particular instance, the judge would have let that testimony in as what we call an excited utterance, meaning what Madison was saying, it was excited, it was in the moment, it was contemporaneous with what was going on. She wouldn't have had the opportunity to make that up, so it's sufficiently trustworthy. We'll let Dawn Schmidt tell the jury what Madison told her. We also got the opportunity for Dawn Schmidt to tell the jury what she saw, her observations, hiding,
under the
all
bed.
Of that stuff is perfectly permissible because she saw it.
Yes.
So yeah, that testimony it provided color for the jury. It allowed the jury to understand what was going on in that moment.
And I think that you brought up a great point in regards to the exception of the excited utterance, because of the fact that she is yelling, and by she I'm talking about Madison Nygaard, whom you will be able to see her testimony. We'll play it for you a little bit later throughout the day, but she was yelling, "He's got a gun, he's got a gun." And we later know that this he individual that she was referring to, she later identified as Jeffrey Willis. So we're getting in that particular statement, and I think that's huge, essentially, for the prosecution. Maybe later on in her abduction case, when that matter is tried, that would be huge as well. But I think that it just shows, like you were saying, it goes back to the evidence that the judge initially allowed in regards to those exceptions that you talked about before.
It's a huge problem, and to me a great issue on appeal, because what the prosecution is being allowed to do, not only prejudice Mr. Willis in an extraordinary way by allowing these other crimes to come into this case, but we talked earlier about the lack of a real good identification here. Well, now you have a really good identification, but in a different case. So if I am the defense, sometimes as the defense, you're not looking for an acquittal. What you're doing is you're setting your case up for an appeal. So what they shouldn't do is do anything to screw that up, like allow the prosecution to get really strong evidence in where the appellate court could say, you know what, the judge did screw up, but there was such great other overwhelming evidence. I think so far we haven't really seen that. So if I'm the defense, I'm playing for that appeal, and I'm playing it conservative. And we saw an example of what happens when you don't play it conservative.
Right. Okay, well, we're going to continue forward in our coverage of Michigan versus Jeffrey Willis. We still have Randy Zelin with us this morning, who is providing some great legal analysis for you, our viewers. What we're going to do is we're going to show you a clip of Diane Schmidt's 911 call, and then we'll talk about this with Randy when we return.